Hi, this is Brian Dolan with the law firm Pepper Hamilton. On a monthly basis, Pepper partner Greg Nowak holds an investment management webinar for West LegalEdCenter. This month, the topic that Mr. Nowak is going to concentrate on are funds and leverage. Joining Greg are fellow Pepper attorneys John Ford, John Falco, Todd Kornfeld, Paul Hespel, and Elizabeth Tabas Carson. The panel will discuss how funds take down leverage, including bank lines, senior debt, mezz debt, securitization, and swaps, as well as cross-border issues, standard documentation set, and U.S. regulatory issues including account control agreements, trust indentures, and UCC filings. You can also download a copy of the PowerPoint slides they discuss by visiting the Pepper Insight Center at www.pepperlaw.com, where this podcast is posted. Thank you.
Good afternoon. This is Greg Nowak from Pepper Hamilton, and welcome to our Investment Roundtable edition for October 2016, where our topic is going to be funds and leverage, or as one of my partners said, fun with leverage. I'm joined today by several of my colleagues here at Pepper Hamilton. We have John Falco, a partner in the Investment Management Group, focuses on 40 Act funds and advisor issues. We have Paul Hespel, a partner in our Financial Services Group, who focuses on leveraged finance and structured finance. Todd Kornfeld, of counsel in the Investment Management Group, who focuses on funds and other exotic structures along with me. And our associate, Elizabeth Tabas Carson, also in the Financial Services Group, who works with Paul, John, Todd, and me on all of our structured finance deals. So welcome all of you, and thank you for joining us this afternoon. As Emily said, we do encourage questions during the program. Please send them, and we will see them on our large screen here, and hopefully address them during the course of the presentation. Don't wait to the end, because we want you to obviously get your questions answered in a timely fashion when they appear during the course of the program. So without further ado, we're going to turn to page, one of the materials, and the question that's posed is, what is leverage? In a fund context, leverage simply means an investment portfolio is larger than its net asset base. Well, how is that possible? Obviously, when investors contribute cash to the portfolio, that cash is then invested by the manager in the portfolio, and the portfolio grows, presumably, through market action, appreciation, interest and dividends accrued on top of the portfolio. But there are ways in order to increase the size of the portfolio and therefore the potential returns for interest and dividends by borrowing money. The borrowing can come from a bank, it can come through the issuance of senior classes, or other ways to gain leverage in the portfolio. It can also come by purchasing certain types of investments that, types of investments that have embedded leverage, such as certain derivatives. And we're going to talk about all of that today. But for the purposes of this presentation, we're going to be focusing on the following types of third-party financing instruments: subscription lines or capital call lines, working capital facilities, securities lending and warehouse facilities, financing for hedge funds, and also certain financing arrangements in the registered fund context. So we go to the next slide. There are certain considerations that need to be taken into account before a fund takes on leverage, and probably the most important of which is the business considerations. What's the potential returns on the assets in which you're investing? Obviously, if the potential return is not greater than the cost of carry plus the cost of setting up the structure, the manager is not well advised to move forward with the leverage. On the other hand, if the potential returns, either through capital gain or interest or dividends earned with respect to the underlying instruments, is significant enough to offset the cost of carry as well as the cost of structuring the leverage, then it may make a lot of sense for the manager to consider bringing leverage into the portfolio. But that's just the business side of things. You also have the investment side. What's the risk profile for the fund and its investors? Because, as you know, leverage in a portfolio magnifies gains as well as losses, and since the creditor will always be paid first, that means you put your net capital at risk potentially in the event that there's a downturn and there's a squeeze on the portfolio. And then, of course, a favor for the lawyers is the legal limitations imposed by the charters and the investment documents of the fund as well as certain regulatory requirements. After long-term capital, it's not possible to lever up a portfolio through traditional structures. After the 2008 market meltdown, no one's done a CDO with 20-to-1 leverage, and so as a result, the regulatory norms on how much leverage can be in a portfolio take on added significance. We're now on slide 4 in your materials. It's important to recognize that not all funds have the same limitations on leverage. Private funds, because they are not subject to regulation per se under the Investment Company Act of 1940, generally have a freer hand in how much leverage they can take on, and they tend to be limited by the counterparty. How much is a bank willing to lend or another counterparty willing to lend to the fund? But registered products are a slightly different kettle of fish. And for that, I'm going to turn to my colleague, John Falco, who's going to walk us through the difference in the amount of leverage that can be taken by so-called open-end funds or mutual funds and closed-end funds, which can either be exchange-traded or interval or some form of liquidity mechanism provided by the manager and the fund in order to maintain net asset value. John?
Sure. Open-end funds are your typical mutual funds. They provide for daily redemption. They're only permitted to borrow from banks, and they're limited to a 300% asset coverage test.
Is that U.S. banks, John, or does it also include foreign banks?
It's U.S. banks, but it can also be foreign banks with a branch in the U.S.
In the U.S., so it still has to be someone who's subject to regulation by the Federal Reserve and the OCC in the U.S. for a U.S. mutual fund to borrow.
That asset coverage test is calculated in a particular way. It is essentially your assets, including the proceeds of your borrowing, and divided by the amount of your borrowing. So if you have $100 in assets and you borrow $50, that means you have $150 to cover $50 in borrowing. So that's 300% asset coverage. Closed-end funds have a little more leeway in the way they can utilize senior securities and leverage. They can issue either debt or preferred securities with different limitations.
Now, hold on a second, John. You're talking about senior securities as if the debt is a security. I thought whole loans were not securities under the federal securities laws.
With respect to the 40 Act, they consider anything the creation of leverage by a bank borrowing to be a senior security under Section 18 of the Act. And probably a broader discussion where we don't have time is whether or not the attributes of a home loan versus a bond are sufficiently distinct to create a different determination as to its characteristics as a security. Under the 40 Act, it's a broader definition of security. So I think there is a bit of difference between a 40 Act definition of security and a 33 and 34 Act definition.
So if an open-end fund borrows from a bank, can the bank syndicate the loan out? I'm assuming there's no limitation on that.
If you mean, I mean, there's, so long as when you say syndicated, it's the lender has to be a bank. So they can syndicate it out to other banks. But the mutual fund cannot borrow from, the open-end mutual fund can't borrow from somebody other than a bank.
So we'll see a syndicated deal amongst bank lenders for mutual fund clients.
Now, moving on to the closed-end side, there's no limitation on just bank borrowings. So you would be able to borrow from any lender. You're subject to the 300% asset coverage test with respect to debt. So if you issue notes or you have a bank borrowing or a credit facility, then it's the same 300% asset coverage that we just went through.
Okay, so let's talk about that asset coverage requirement. If I have a fund that has $200 million in assets, we're looking at an open-end fund, okay? So $200 million in assets, and it borrows $100 million from a bank. So it has proceeds of the bank debt of $100 plus the $200 of assets. So now we have $300 million, and I have $100 of debt outstanding. That would meet the 300% asset test.
Yes, 300 divided by 100.
Okay, so the problem that you have then is market movement. If there is a decrease in the value of the assets purchased by leverage as well as the net assets in the fund, what is the impact then on the leverage? Do you need to immediately trim the debt?
The asset coverage test applies immediately after. You can't have more than 300%. So you can go above or below, but there's implications under the 40 Act if you don't meet that 300% asset test. One of them is you can't issue a dividend, so you can't make distributions, which is bad for an open-ended investment.
Well, it also potentially causes them to lose their qualification under the federal tax.
Exactly, that's right. There's a risk status. So in practical terms, you always maintain a 300% asset leverage.
So that means the number is actually significantly smaller than 300%.
Typically, you don't go up to the limit. You have a little room for market movement.
So tell me a little bit about preferred stock. I remember as a really, really young kid, my father bought some shares of Vanguard Gemini Fund that had senior securities as well as junior securities. Now, the Vanguard Gemini Fund was a closed-end fund. It has since been wound down. But is that an example of a closed-end fund with a senior security that's a preferred share class?
Exactly. And you have preferred that are junior to debt and senior to your common. And what that means, at least under the 40 Act in Section 18, is that you are given a little more flexibility as to the amount of leverage that you can use. For closed-end funds, 200% asset coverage test. It's a little different in the way you calculate it because you have to include in your senior securities with respect to debt. So the calculation is a little different in the sense that it's your total assets plus the proceeds of your senior securities divided by the liquidation value of your preferreds and the amount of your senior securities that are debt or your borrowings.
And can I do both? Can I do debt and preferred in a closed-end fund?
You can, but you're still subject to the 300% limitation for the debt, and then you have the limitation for the 200%. And I'll give you an example. I like to use $100 increments because it's easier for me to do the math. If you have $100 and you have $50 in bank borrowings, that means that for the asset coverage test with respect to debt, you have the 300% coverage. Now, when you go to do your preferreds, the coverage is a little different because you've got to include your $100, your $50, so you have $150 in assets. If you could do another $50 in preferreds, which would give you $200 in total assets, and then against or divided by your $100, which is the $50 in debt plus the $50 in preferreds, which again gives you it's essentially one-to-one. You have $100 in assets against $100 in liabilities. $200 divided by $100 in liability gives you the 200% asset coverage.
So, moving to slide 5, business development companies, BDCs, are a form of closed-end funds, but they're not necessarily closed-end funds per se. They're treated as closed-end funds for certain purposes of the Investment Company Act of 1940. But there's a different leverage rule, and what's that? How does that work?
The leverage rule is really with respect to debt. So whereas for registered open-end and closed-end, you can have 300% asset coverage. For BDCs, it's one-to-one, so it's a 200% asset coverage test, which means you've got $100 in assets, you can borrow $100 or issue $100 in notes, and you've got $200 to cover $100 in liabilities from the senior securities.
We've covered BDCs in previous editions of this program, and I'm sure the materials are still available in the Thomson Reuters catalog. But the point is BDCs have become a very popular vehicle because they're sort of private equity funds on steroids. They're publicly traded. You can have a performance-type fee, and you can nevertheless have a broad distribution because it's a registered product. And so in many respects, BDCs, provided you can meet the definitional requirements, provide a unique alternative to closed-end funds, and we'd be happy to talk with you about that. Feel free to call either John or me, and we could talk in more detail about that. But now I'd like to turn to Todd, and Todd, if you could give us a quick primer on how private funds, hedge funds and private equity funds, differ from the three registered categories that we just mentioned, closed, open, and BDCs, specifically lasering in on leverage.
There aren't any legal or regulatory requirements that are directly imposed on private funds themselves from a borrowing point of view, except perhaps for margin rules under Reg E, Reg U, and the Federal Reserve. So,
what are those? Can you give us a little bit of, high level, 30,000-foot background on what Reg E and what Reg U do?
These go back to the 1930s and the Great Depression. Basically, they limit how much money a bank or broker-dealer, or for that matter, any party, can provide to somebody who's using the loan to buy securities that are exchange-traded. And exchange, in this case, would include NASDAQ. So it basically prevents somebody from borrowing a great deal of money at very high leverage to buy listed securities. And that limit is, there's different ways it's calculated depending upon, exactly how you're doing your leverage. But typically, your lender is more concerned about their credit in a lot of cases before you run into the Reg T or Reg U margin limits. So that's not really a focus that people typically have. Your classic hedge fund is borrowing from its prime broker, and in many ways it's very similar to a margin account that you might open up yourself, with a broker like E-Trade or the like, for your own personal use. You put, the hedge fund puts in, $3 million of equity, and then the prime broker allows them to borrow, additional amounts to buy securities. And there are different ways that can be calculated. There's margin portfolio lending, which typically lets you go up perhaps to 4 or 5 to 1, ratio on the margin. There are SEC requirements on that, again, on the lender, not on the fund itself. But again, typically the lender is more concerned about the credit risk it has than the actual, you'll hit that limit before you hit the limit on how much leverage they can legally provide.
Now, we sort of hinted at the tax requirements. We were talking about the distributions and the limitations under the 40 Act of making a distribution. One of the most important things to keep in mind is in a registered product, since it is a corporation for federal tax purposes, the leverage is bottled up inside the fund and does not taint the investors. Whereas in a private fund, like a hedge fund or a private equity fund, if there's leverage inside the fund, then the investors will have UBTI, especially if you're a pension plan, an IRA, or some form of endowment account or charity that's investing in the fund, then the UBTI will pass through to you because it's considered debt finance portfolio income. Now, word of caution, if you're a charitable remainder trust that's investing in a fund that has the possibility of leverage and it's a pass-through fund, you will blow your status as a charitable remainder trust. And so UBTI is poison to CRTs. You need to be very careful about the nature of the investments that you're going into with CRTs. So now I'd like to turn to Liz, who's going to walk us through some of the limitations and considerations on leverage. We're on slide 6 of the materials. Liz?
I think, obviously, it's tailored to the fund and their fund documents. And when you're looking at making an investment or taking on leverage, it's really important to think, what type of entity is this? Where is it organized? What do my charter documents say? Is there something in the local law that will either from a tax perspective or a disclosure perspective change the type of deal I can do? And are there limitations on if my deal can be secured or unsecured? And it's very deal-specific, entity-specific. But it's really important to come to people like us, if you're thinking about doing a deal with leverage, to understand what is permitted. Okay.
So give me an example. Where would something like this be buried in a charter document? In the authority, in the limited partnership agreement of the general partner, for example, of what they can and can't do? Or will there be some other, provision that you always look for in doing due diligence on a potential borrower to make sure that they have that authority?
Well, it depends on where they're organized. I think the best early starting point is to go to the charter documents and see, can they borrow, can they guarantee, can they provide a security interest, who can authorize that? That would be a basis. And then looking at where they're organized. So, for example, if you have a Cayman fund, although they are Cayman entities that are look-through entities will look back to where their owners are. So if you have a Cayman fund that has a U.S. parent, you look to the U.S. And so you'd end up in a situation where you'd have to be cognizant of both sets of rules in some cases. And so it's really important to understand that. And in terms of your disclosure, again, it depends on where you're operating, what your disclosures are, what you disclose to the public if you have a fund that has public disclosures versus a private fund, which may not.
Paul, we've talked about a couple of different ways in which debt can be incurred inside a fund, and have been focusing primarily on the borrowings by a fund to lever up a portfolio. But there are other ways in which banks will lend money to either investors or to funds. Why don't you walk us through some of those?
Correct. I mean, I think what we're talking about here, probably the first instance, is what we refer to as the liquidity lines or capital call lines or subscription lines, which are essentially a measure of the ability of a fund to have debt incurred in order to bridge the period between when the capital call is made and when the capital call proceeds are received by the fund. So essentially a revolving line that often when the fund makes the trigger on the investment, it doesn't want to obviously do it too early given the contingencies in deal execution, and therefore they will essentially bridge that period of the capital call. So these lines can be structured in many various ways, but historically they were initially provided, especially in the real estate fund space. It has expanded to private equity funds and other types of closed-end private funds. So typically they're committed lines of credit. They can be uncommitted. They're generally within a period of time that corresponds to the investment period of the fund, whether it be 1 or 3 years. And the size, as a rule of thumb, is probably half the size of the capital commitments of the funds that are unfunded at that point in time.
And we're on, for those following along at home, we're on slide 8. Would these lines be the debt of the subscriber, or are they the debt of the fund?
They're to the point that they can be structured in various ways, but they are either the debt of the fund themselves or the debt of the managers of the fund, but guaranteed by the fund. And the recourse ultimately is structured in such a way that it is secured, either the guarantee or the primary obligation of repayment is secured by the capital calls of the unfunded capital commitments of the investors that remain outstanding. So it can, in some cases, in very minor situations, for instance, in the private equity space, also be secured by the portfolio company assets, because the idea is that a temporary financing is put into place before an ultimate final refinancing occurs at the portfolio company level. So the collateral is really the fund pledging its unfunded capital commitments, basically pledging the cash that is in the accounts of the funds that represent the unfunded capital commitments, and essentially a grant of a security interest in the ability of the general partner to deliver the capital call notices to the investors. So that's sort of generally the type of structure these subscription lines or capital call lines have. Obviously, they can be made bespoke spoke to a particular fund and its structure. One side note on this is that these capital lines tend to be secured, except in the SBIC context. The Small Business Administration does not allow for its funds that are SBIC qualified to grant a security interest in its assets. And that comes up in the case when there is a main fund with a sidecar SBIC fund or a drop-down SBIC fund, where you at that point have to carefully structure around those limitations of the SBIC.
Well, that makes some sense, since the SBIC is providing significant leverage to the fund and therefore doesn't want to be in a junior position, presumably. So there is some elegance to the SBIC's refusal to allow that. But tell us about the likelihood of a lender demanding a guarantee, a comfort letter, keep well, or other credit support from, I'm assuming, the manager, because here it's the fund that's borrowing the money in anticipation of receiving the capital contribution. It's already pledged the subscription agreements as collateral, and now, obviously, the bank is looking for more credit support and wants it from somebody else. Why would a manager do that and put its own assets at risk?
Yeah, I think it's a very unusual situation. I think you would see it in more complex structures where there's international aspects to the transaction with overseas funds, and sort of alleviate the concerns of recovery towards these foreign funds. Additional parties might be required to provide the credit support.
So, a word to the wise, those of you who represent endowments and other potential investors, even though a fund itself may not incur leverage as an investment proposition, if the fund is incurring leverage with respect to a subscription line or a capital call line, it's very possible that you still would have debt finance portfolio income inside the portfolio, which, you may not know or understand. Now you're in the position of filing a 990T on an annual basis for tax purposes. Turning to slide 9, Todd, how does the financing arrangements for hedge funds work in this regard?
Well, again, classically you use a prime brokerage account with a U.S. dealer, and typically, let's say you're in portfolio, margining, so you might be up to 3 or 4 times leverage. One of the things to be concerned about with any financing arrangement for a hedge fund is you have to repay your dealer or your financer. And the question is, you have to pay them back immediately upon demand, which is classically the way prime brokerage works. You have some sort of lock arrangement with your prime broker, which larger funds sometimes have, which may give you some notice protection before repayment is required. You have some other type of structure that allows you definitively to have time to repay them. You have to post collateral. Where is your collateral going? For example, in the pre-Lehman era, people used offshore financing through the UK, which allowed very high leverage in some circumstances, but you had to pledge everything back to the dealer. When the dealer went under, it was very, very hard to get your property back. These are all things you have to think about, the balance between the financing rates that you're getting, the availability of leverage, how quickly you have to repay, what notice requirements there are, and where your assets are being held, and what risks you have in not getting them back. And a related point to this is disclosure of the fund, which should make it clear, what types of financing are contemplated the fund may use, and what the risks that are entailed in those financings may be.
Yeah, we've seen fund structures where the manager sets up a blocker entity, usually an offshore corporation, in order to minimize the flow-through of the leverage and the liability to those investors. One way to do that is almost a bespoke structure, where I call it a feeder hotel, where you set up a ring-fence series company in Caymans, and each investor comes in through their own series. Right, and that investor can decide whether to check a box for federal tax purposes to act as a blocker or not.
Right, the UBTI issue that you were discussing earlier.
Right. Yeah. But tell me a little bit more about the synthetic structures. Back again several years ago, before Lehman, it was not uncommon for a bank to provide leverage through a senior swap facility. Right. whereby under the bankruptcy laws, the swap takes precedence over everything.
Right. And there still are people who do very, very large portfolios, for equities, for example, via total return swaps. These are very generic, very simple total return swaps that essentially replicate owning the cash equity. And people do that for a number of reasons. Some of them are to get enhanced leverage or better leverage. Sometimes the dealer is willing to lock up the financing for a certain period of time or commit to certain rates. And there may also be advantages of some jurisdictions, South Korea, for example, where it may be difficult to actually buy the cash equity, or in Hong Kong, where there may be advantages from a stamp tax issue, or the UK, in buying synthetically. So there are a number of reasons that people do that, not just because it's better leverage or quote-unquote safer leverage or cheaper leverage. There are a variety of reasons that people might do that, and still very active in equity markets right now. People historically have also financed bank loans and various types of bonds through total return swap facilities. Those tend to be a little bit different. In the case of normal listed equities, it's easy for a dealer to give you a list of if you buy a UK listed equity, here's a leverage I'll give you, we're done. When you start to buy bonds and bank loans, they're not really fungible. The dealer doesn't really know what the credit profile is. So sometimes you have to get each individual credit that you buy pre-approved by the dealer, or the dealer may be willing to give you parameters. But those are generally more bespoke, more custom facilities as opposed to equities.
So you were just talking about the fact that your prime broker is the normal source of leverage. The prime broker is an on-demand financing. Aren't there available permanent sources of financing in the hedge context? But we're on slide 10 for those of you following.
Well, people have done things like they've sold 144A debt notes to the market that are term notes that have given them a permanent source of financing. That's a large fund. It's hard to do, but people have done that successfully. There are some types of swap facilities and prime brokerage facilities that are relatively committed and may go out for a long period of time. People have thought of more complicated structures. For example, if you buy all the equity in a CLO or CDO, you give your hedge fund all that equity, and then the CLO or CDO is issuing debt, term debt out in the markets, essentially the hedge fund has now obtained leveraged financing, leveraged exposure to the market, and the CDO or CLO has term notes, for 5 years, you have that financing available at that rate. It's not going to be recalled during that time, with no early demand for payment, and the like. People have actually been quite successful in doing that.
Well, that's just another way of saying I'm going to structure this as a special purpose vehicle.
Right.
Where I'm going to create a leveraged finance subsidiary where the hedge fund would own 100% of the equity of the leveraged finance subsidiary, and that subsidiary would then issue debt.
Right.
Whether it's bank debt or CDO debt or however you want to describe it.
A key distinction here is how is it structured, how is it leveraged, and how demand is the debt. And people, again, in 2007, 2008 vintage, there were listed vehicles in the UK called CIVs that sometimes had leverage of 100 to 1. They had an equity, a junior debt, and a senior debt, and they were thought to invest in stable asset classes. People found they weren't so stable. They were in market, which most CDOs are not. And when things went wrong, they were required to liquidate rather quickly and rather disadvantageously. So in structuring these things, there's a balance between how much leverage do you want versus is it a mark-to-market vehicle or not.
Paul, that's a great segue into some of the limitations and restrictions that we have in financing hedge fund debt. We're on slide 11, those of you walking through. Tell us about some of those difficulties and ways to work around them.
So, the point here that we're trying to make is that obviously there's always the ability to sort of lever up the investment in the fund itself rather than the fund as such. And, obviously in most cases this is really a product of private banking and really a loan to an individual or an entity that is set up with the purpose of investing in a hedge fund. Obviously the quid pro quo for that is often the grant of security interest in the hedge fund itself, which sort of has its own sort of issues and diligence requirements from at least the lender's perspective, in the sense that it can interest be granted, what's given the laws and the organizational documents, what's the extent of the security interest that can be granted? Is it just an economic interest? Is it more than that? Does it include central rights, such as voting rights? If there were to be a foreclosure on these interests, what are the rights of the lenders to come in and be considered an LP or a member of the entity to the same extent as anybody else? The other way that you sometimes see is that there's a fund-to-fund structure where obviously the leverage is not provided at the hedge fund level itself, but rather at the fund level that is in itself appropriately levered up to make the investment, on a consolidated basis into a particular fund as such.
So let's get down into the nitty-gritty, Liz. How do these things actually work on a day-to-day basis? I've heard tell of banks essentially requiring every dollar of cash that comes into a fund being paid into the bank to pay down the line, and then the bank, if there is a disbursement to be made, to pay legal fees, to pay accounting fees, to pay a custodian, to buy an investment, all has to be done by a withdrawal on the borrower base. How does that work, and is that a typical structure?
It depends. It's driven in part by the credit quality of your borrower, and so you will see a more restrictive facility for a borrower that's less investment grade. When you get more risky, they want more controls, because obviously having controls on cash means that they can quickly, lock down, get the money out, and not allow as much leakage as it might otherwise. And so it really depends on the situation, but I would say it is quite typical that if you have a borrowing-based facility, that for the fund, a few things to keep in mind, even if you have your 40 Act requirements or some other leverage rules that you're bound by, your credit facility is going to be tighter. Your disclosure is going to be tighter. And your bank might like you to have your accounts also with them because it's good business for them. And also from a perfection point of view, it allows them to know they have control. If not, you're talking about a DACA, which is quite typical if you're doing a syndicated deal rather than a bilateral deal.
What's a DACA?
Deposit Account Control Agreement. Or if you have securities, you'll have a Securities Account Control Agreement, which is a tri-party agreement.
There's actually an interesting difference here. Because you're in the registered fund context, the lenders probably has difficulty getting a good lien on the assets of the fund directly.
Registered, they tend to be unsecured.
Right, exactly. Whereas when you're in the private fund context, you don't have those rules and regulations. So typically your prime broker has complete lien. They're holding your assets. That's where your securities actually are. And so all they care about is that you have enough cash and stuff in there to meet the margin requirements. So if you're banking away from them, that's fine. If you're maintaining minimum margin, that's fine. And many funds that have sophisticated operation size will keep the bare minimum cash they have to in the account. They'll move it in and out on a daily basis.
From the registered fund side, the source of that distinction is really the custody rules under the 40 Act, which require that the fund's assets be held in the custody of the bank.
We're a broker, but nobody really does it because of the rules under Section 17F make it difficult and not really desirable for a broker to take custody of assets. And rarely do they do it. I haven't seen it in my career, except in very limited circumstances.
But because the assets are pledged and they're not the lender's assets until they're actually taken or there's a default, the assets of the registered fund need to stay in custody of that.
Right.
So, moving to slide 15, it's important for you to understand who your investors are and whether or not there are side letters or other limitations. You very well may have sovereign immunity with respect to assets in your fund if they are owned by a foreign sovereign. You might have some limitations on transfer rights. There may be an obligation to deliver an investment letter or an opinion. I mean, there are all types of limitations that come from securities law, tax law, state finance law, the bank debt. Liz?
I was going to just say, the other thing is, depending on what's in your portfolio, where your accounts are, there'll be different rules that will spread across jurisdictions. So, for example, going back to the control agreement, in the U.S., you use tri-party agreement to let the bank have control, quote unquote, in the UCC bank. In the UK, you send a notice, and most of the rest of the world, you send a notice to your depository institution, to your broker, and there's no formal acknowledgement of it. And so it's really important to understand the differences, the cost of those differences from business perspective.
And the biggest question in the equity markets is where are my securities? I have my friend look pretty much my U.S. dealer, but half the stuff on my account are security to trade in the UK or Singapore or whatever, and there are a variety of local custodial arrangements. And, local law, if things go wrong and there's foreclosures, you're going to potentially be involved in multiple jurisdictions if your dealer goes under. And in addition, the overseas custodial accounts are probably full fungible accounts in the name of the dealer, not his warning. And these are all questions that things to consider, especially if unusual and custom finance arrangements that you and the dealer built just for you spoke, and there may be risks that you're not thinking of from your investor's point of view.
So, just to put all of this in context, any of you who've ever been involved in a debt facility for a corporation know that the lender always wants an opinion that you are not required to be registered as an investment company under the Investment Company Act of 1940. And then you're going to get a certificate from your lawyers to be signed by an officer that says you have never issued a face amount certificate, that you don't issue redeemable securities, that you have none of those securities outstanding, that if you hold securities on your portfolio, it represents less than 40% of your assets, and your income, less than 40% of your income is from investments. And the reason for that is if you are found later to be an investment company that was required to be registered under the 40 Act, John, what happens to the debt?
I mean, under the 40 Act, you have the ability, if it's not compliant with the 40 Act, it can void the terms of the contract.
Right. So that would mean that a business company would have asset coverage requirements, et cetera, that have not been met, and as a result, the debt is void. And so the result is catastrophic for the lender, so the borrower gets a windfall.
Well, I'm not sure if that's exactly the case. I think that it's likely that in a court of equity, the borrower is not going to get the benefit of not having to repay the debt. But it does complicate matters because you have to actually go through the 40 Act and get to a place where you're in equity rather than law in the courts.
So, slide 17, working capital facilities for hedge funds, notwithstanding, or registered funds rather, notwithstanding all of these limitations, there are still people out there who are willing to lend to a registered mutual fund.
Well, certainly. I mean, if you think about it, you have 300% asset coverage, and so
we're talking about a low-risk loan. Right?
Particularly open-end mutual funds, you're talking about a portfolio of highly liquid securities. I mean, the liquidity limitation is that you've got to have 85% of liquid assets, and you can only have 15% of the liquid. And with 300% asset coverage on readily priceable securities, there's not a lot of risk that the money isn't going to be there. So I think that's the reason why a lot of these credit facilities with respect to open-end funds are unsecured, and banks can be comfortable with that because they know there is a pool of assets there.
But let's talk a little bit more about how does that asset coverage test work. I mean, Liz mentioned an account control agreement with a tripartite agreement. There have been enforcement actions recently where funds have failed to use the tripartite agreement, and as a result, the SEC came in and said that the assets were being held by an unauthorized custodian because they were deposited as initial margin with a non-authorized leverage provider. So what exactly is the issue there?
Well, the issue is that the lender wants to have a portion of assets that cover the loan in an account that they can go and reach into in the event of a default. Well, from the 40 Act side, the assets need to be custodied with the bank, and so
it's been approved by the board of directors of the fund.
Yeah, it's approved by the board, and just as it is the regular custodian, and oftentimes it is the regular custodian bank that is setting up a segregated account where the assets would be placed, and to the extent that there's an event of default, the lending bank could go in and grab those assets.
So it's okay for a mutual fund to pay against a trade ticket. I'm buying this security, and that security moves into the custody account with the bank that holds that particular asset. The problem arises where there's an open liability balance where the mutual fund has agreed to pay something to someone else and then to post collateral with respect to that. So think of a swap, for example, where it's a total return swap and the mutual fund has opened up an account with the brokerage firm and is being asked to post initial margin with the brokerage firm. Right. And the problem is the brokerage firms want that because then they rehypothecate the funds and it reduces their costs in the swap. The 40 Act, on the other hand, does not allow all those assets to be held outside of the custodian of the fund. And so under a SEC ruling practice, number 10666, which has been around for 30 years, as long as the account control agreement segregates those assets, everybody's happy.
Well, 10666 stands for the principle that certain types of transactions, a swap agreement, short sale, will not be deemed to be a senior security and are subject to the coverage requirements under Section 18. What that means, and in order to conform to the guidance under 10666 and various staff no action letters, you have to have liquid unencumbered assets segregated or earmarked against the liability to cover it 100%. And so, again, it goes down to custody because those assets are covering, they're not being given, or they're still the fund's assets. They have to be placed in a qualified custodial bank. And so, again, you need for those types of transactions, even though they're not senior securities, they do create leverage, and they do need to be any margin accounts or any collateral needs to be placed into a segregated account to cover the position.
So 10666 is now in flux, right? There's been a new proposal by the SEC staff for adoption by the SEC Rule 18F-4, which would rescind prior staff guidance and replace it with what? We're on slide 20 for those of you following along.
Well, yeah, the 10666 it will be rescinded. 18F-4 was a proposal to essentially make the only means in which funds can enter into certain derivative transactions and financial commitment transactions like short sales, reverse repos, futures, and swaps. It would be through Rule 18F-4, and it would rescind the 10666 and the subsequent staff guidance. According to one of the SEC commissioners, it's not going to be adopted this year. I think 2017 it's unlikely, and how it actually ends up is a little bit, as Greg said, it's in flux as to whether or not the rule is going to be adopted as proposed.
Well, doesn't the rule as proposed bring an extreme prominence to the concept of VAR, value at risk? And you are now being asked to bring in an investment concept for purposes of a compliance rule, which would be the first in my experience that the SEC is using a statistical measure.
Yeah, I mean, with respect to the the derivatives the requirements and the rules, there's two different ways you can comply. One of them is looking at VAR, and so there's going to be the 300% coverage requirement, which looks to make sure that you either have to do an exposure-based limit, which is the VAR issue, or a 300% risk-based limit on all senior security transactions. So what that means is that you either look at a single transaction and you're limited to 150% of exposure, or you look at your entire leverage transaction, senior securities plus your derivative positions.
So, as John said, and I said previously, whether or not 18F-4 is adopted is still a question. It obviously has been proposed. It's been sitting out there for almost a year, and without significant movement, although we have had these coffee clutch comments by members of the Commission essentially saying that not this year, probably not next year, but it's still out there as a viable proposal. In our remaining time, which is about 8 minutes, Liz and John, I'd like you to walk us through securities lending and how securities lending in the portfolio could be viewed as leverage as well as the common pitfalls for a fund. So, Liz, on slide 24, we've got who are the common lenders in a securities lending transaction?
As it says in the slide, U.S. and foreign regulated funds, insurance companies, pension funds, central bank foundations, endowments, institutional investors, and I guess really anyone who would want to be involved in the lending transaction would hold those assets and get some additional return.
And common borrowers would be?
Common borrowers would be banks, broker-dealers, so a broker-dealer acting on behalf of perhaps a hedge fund client or someone else who would like to use those securities and influence their strategy with it.
And they get a little bit more income because they get the interest on the collateral that is provided by the borrower. In addition, they may get some short rebate concession, which is for hard-to-borrow securities, they actually get an incentive. They get a higher interest rate in order to lend those securities out.
But, John, if I'm following the arrows correctly, in a registered fund context, I'm not taking on leverage, I'm providing leverage.
The Commission's taken the position that they've essentially applied Section 18F, and they said it's akin to a senior security because there's a contingent liability to return the collateral provided by the borrower. And so the limit for registered funds is 33 to 30.
So it's still 300% asset coverage if the fund is engaging. Where they're acting as a lender of securities.
They're lending the securities, but they're receiving collateral in liquid assets, and they have a contingent liability to return those assets. So, again, they view that as something akin to a leverage transaction. But interestingly, they've accepted securities lending from the full proposal with respect to the new derivatives rule in 18F-4. And because it is not a borrowing transaction, it's a lending transaction. But the guidance is 1/3 of the portfolio because you have the contingent liability to return the collateral when the borrowed securities are returned.
Now, I've heard from portfolio managers who are interested in doing this that it's essentially a riskless transaction. Liz, slide 30. Tell us some of the risks that they have to look forward to as they implement this so-called riskless strategy.
Well, since we've been talking a lot about Lehman, we'll go back there. I think a big one is counterparty risk and knowing that you can get your securities back. So in 2008, if you had Lehman as your prime broker and you were in one of these transactions, when the music stopped, a lot of people had issues because especially in the UK, they were held with a trustee. Okay.
they were using the offshore financing technique, where maybe we'll have another presentation some other day. But if you're using a U.S. prime broker, this 15C33 protects you. So in theory, if things are done correctly, you should be okay if your U.S. dealer blows. But the UK at that time had no customer protection requirement whatsoever for a hedge fund obtaining leverage.
But does 15C33 apply in the context of an account agreement that allows rehypothecation?
Yes. Yeah. It does. But one of the questions that people try to negotiate this, there's different views in the market. 15C33 probably applies to the dealer's entire book in aggregate in terms of how much they have to, maintain. But again, we can talk another time about that. It's actually an interesting topic. But in the case of the Lehman, people were doing via UK Lehman, doing securities lending, and Lehman blew up, and the argument is, I'm holding collateral. Okay, what's the collateral? And some of the stuff that people got back as collateral hold was what had been AA or AAA rated CIV-issued securities, going back to an earlier conversation we're having, and it turned out those ratings were rather optimistic, and people discovered they were holding paper that really was worth 80% of par, and they liquid to boot.
Well, actually, even worse than that, they couldn't get it out because of the UK bankruptcy rules. The trustees weren't able to release them and complete the trades. And so then you get into this reinvestment risk, operation risk, realization risk, because it's tanking and you can't move it. And so it's really important, again, to understand what you're investing in. And if it's cross-border, to understand what that means. And
even though securities lending appears to be a collateralized loan, in reality, there's a lot more hair on it at first glance.
So, John, on page 32, or slide 32, we have the collateralization limitations required for registered funds. We have about 2 minutes, so you have a minute, because I want Todd to talk about collateralization requirements for private.
Sure. I mean, the minimum is 100% the amount of the amount of loan securities. Typically, it's 102% collateral that's required for domestic equity, and 105% for foreign securities. That's really to make sure that you keep it to 100%, and you're not moving money back and forth in the collateral account with market movements, and because it's a mark-to-market daily collateral.
And how much can the securities lending program aggressively add in terms of additional basis points to the return of the fund?
It really depends on the securities that you're lending. If you have large securities and your short rebate is, it can be substantial. It can be between 5 to 20 basis points
of additional annual return attributable to.
Well, yeah. I mean, really, reduction in your expenses and resulting in more return.
And Todd, what about private funds?
Well, the collateralization requirements are similar to market and credit driven, but you have more flexibility in the collateral that the lender can get back. And what people again did in the pre-Lehman era was they'd get cash, back from the borrower, and they'd invest that in something they thought was highly rated and liquid, and collect 20 or 30 extra basis points off that. But again, what they were investing in sometimes turned out not to be so liquid and not to be so stable value-wise, and that caused a great deal of difficulty for people.
Yeah, so some of and I agree, it was the collateral that really was the problem. A lot of these sec lending programs that are sponsored by brokers or custodial banks, they indemnify for the counterparty risk. So if the securities aren't returned, then they'll make the lender whole. It really is the decision on how to invest the collateral, because if you as the lender take that collateral and put it into junk for somebody that defaults, that's your investment decision. It's not a decision.
And a fair point on the prime brokerage context, if you have a margin account, the dealer is lending your securities out in compliance with law. You don't get any extra payment for that. That's just the way it works. The dealer has to do that to finance your own position.
So we are about out of time. I'd like to thank you for joining us this afternoon. I'd like to thank my co-panelists for their insights and comments. Thank you very much.